An inquiry about the effect of electoral irregularities and other malpractices is necessary where an election court has concluded that the non-compliance with the law relating to the election did not offend the principles laid down in the Constitution or in that law. When a trial court has made a determination that the election was substantially conducted in accordance with the principles in the Constitution and electoral law, it is incumbent upon the court to inquire into how any proven irregularity affect the result of the election. In this regard, we are guided by the Supreme Court dicta in Raila Amolo Odinga, as cited above. The trial courts are in using the phrase irregularities must have effect on the result instead of affect the result. Learned counsel for the appellant, Otiende Amolo, submitted that the trial court erred in law when considering the legal effect of irregularities. That the court considered whether the irregularities had effect on the result instead of whether the irregularities affected the result. That the proper test is whether the irregularities affected the result. It was urged that the phrase effect on the result and affect the result have completely different meaning in English language and in law. By adopting the test of effect on the result, it was contended that the trial court erred and arrived at a wrong conclusion. In counsel's view, an irregularity can have effect on the results without affecting the result. The trial court, in dealing with the irregularities, expressed itself as follows at paragraph 126 and 172 of the judgment. And I quote 126, the effect of the alleged irregularities must be calculated to really influence the result in a significant manner. Whereas the word effect in ordinary English means consequence of something, the word affect means to impact or to cause or change in some way. The two words are most times used interchangeably as they more or less mean the same thing, but in election matters the word affect is dominantly used. In considering the appellant's submissions, we keenly know that the trial court explained that in election matters the word affect is predominantly used. The trial court, in citing a persuasive Ugandan case, noted that it must be shown that irregularities affected the result of the election in a substantial manner. However, at paragraph 173 of the judgment, the trial court in alternate uses affect or had effect on results. The explicit wording in section 83 of the Elections Act are affect the result of the election. It is latent and plain that the phrase effect on the result and affect the result has different meaning. Hypothetical example would suffice. For instance, assume that the margin between a winner of an election and the runner-up is 5,000 votes. Upon recount, the margin reduces by 1,000. It is clear that the results of the recount had effect on the results but did not affect the result. This example suffices to demonstrate that in determining the effect of any irregularities, a court must confine itself to the explicit words in Section 83 of the Elections Act and determine if the irregularities affected the result. We reiterate that the correct test is affect the result and not effect the result. We have reviewed the judgment of the trial court to determine if in totality the use of the phrase effect on the result led to a wrong conclusion and determination by the trial court. We find that the trial court, in evaluating the evidence, correctly laid emphasis on whether the irregularities were substantial, but also that they affected or had an effect on the results in a substantial manner. By adopting the substantial approach, no error of law was committed by the trial judge in stating that the irregularities should affect or have effect on the result in a substantial manner. This ground of appeal has no merit. The binding nature of judicial scrutiny report and whether the trial court erred in failing to consider the scrutiny and recount report dated 24th of January 2018 by the Deputy Registrar. During the hearing, the trial judge directed the Deputy Registrar to supervise access to election material and conduct scrutiny and recount of votes. The Deputy Registrar prepared two reports. We have reproduced the contents of the reports. The content and findings in the two deputy registrars' reports and the probative value of the reports are matters of contestation. The third and fourth respondents filed their own observations, which in material aspects are contradictory to the deputy registrar's reports. Neither the appellants nor the first and second respondent filed observation to any of the deputy registrar's reports. The observations filed by the third and fourth respondents are what the trial court refers to as the petitioner's reports. In this appeal, the appellants refer to the third and fourth respondents' observations as the Kanjama and Homa reports. The appellants admitted that the critical finding in the Deputy Registrar's scrutiny and recount report dated 24th January 2018 is that upon recount, the first appellant not only remained the winner of the Homa Bay gubernatorial elections, but his vote tally increased by 14 votes. The appellant's major contestation is that the trial court erred by ignoring the Deputy Registrar's scrutiny and recount reports, particularly the finding that the first appellant had garnered the greatest number of votes and his vote tally had increased. The appellants contend that the trial court erred in failing completely to refer to the scrutiny and recount report of the Deputy Registrar dated 24 January 2018 and instead relied on the Kanjama and Homa report filed on 31st of January 2018. They observed that the Kanjama and Homa report was not subjected to cross-examination and the author, learned counsel Mr. Kanjama, was not called to testify. They submit therefore that the probative value of the Kanjama and Homa report is 0 when compared to the judicial scrutiny and report dated 24th January 2018 prepared by the Deputy Registrar, since the Deputy Registrar is an officer of the court and the report was prepared after physical examination of the ballot boxes and recount of votes. Senior counsel Tom Ogenda vehemently submitted that the findings in a scrutiny and recount report undertaken pursuant to and under the supervision of the court bind the trial court. That in the instant matter, the trial court was bound to take into account the findings of the scrutiny and recount report, which indicated that the first appellant was the winner of the Homa Bay gubernatorial elections. That the Deputy Registrar findings of facts bind the trial court, and it was a fundamental error to ignore, fail to consider, and even fail to refer to the findings of fact made by the Deputy Registrar, who physically saw the ballot boxes, the seals on the boxes, and supervised the physical recount of the ballots. That the Deputy Registrar's report is direct evidence with a high probative value. In rebuttal, the third and fourth respondents urged that the trial court neither ignored nor failed to consider the scrutiny and recount report dated 24th of January 2018 and prepared by the Deputy Registrar. That the court considered and weighted the report when evaluating the totality of the evidence on record, and that paragraph 160 of the judgment is proof that the trial court considered the report by the Deputy Registrar. The appellants contend that by a ruling delivered on 7th of November 2017, the trial court indicated that scrutiny and recount exercise was to determine the votes garnered by each candidate. That the court erred in failing to take into consideration the votes garnered by each candidate as determined by the scrutiny and recount report, thereby erroneously departing from its ruling where the judge stated, I quote, in that regard and in terms of section 29, subsection 4 of the Election Petition Rules 2017, the scrutiny of the votes garnered by each candidate shall include recount and ascertainment of votes garnered by each candidate in each of the polling stations specified in paragraph 33 or 34 of the petition, and any other polling station that the court may, in the course of taking evidence, deem fit. End of quote. In considering the Deputy Registrar's report, the trial court observed as follows. Some forms were altered in ink and did not reflect the originals, and some did not have visible or clearly visible entries. Some of the forms were photocopies. As for ballot boxes, some were broken and a considerable number were secured with unofficial seals. A reading of paragraph 160 of the trial court's judgment clearly shows that the Deputy Registrar's scrutiny and recount reports was not referred to. Scrutiny and recount pursuant to court orders are important in three situations: where it is the only plea in the petition, where upon recount of the ballots cast, the winner is apparent, and lastly, where the margin of victory is narrow. Recounts not only assist in the expeditious disposal of election petitions, but they also enhance transparency and public confidence in the electoral dispute adjudication. The contestations around the Deputy Registrar's scrutiny and recount reports leads us to examine the emerging jurisprudence on the probative value and binding nature of judicial scrutiny and recount reports. At this stage, we are not considering the contents of the Deputy Registrar's report filed in this matter. We only consider the probative value and the binding nature of such reports. Emerging jurisprudence shows that the trial courts have considered and evaluated scrutiny and recount reports filed by Deputy Registrars. This emerging jurisprudence emphatically shows that a judicial scrutiny and recount report must be considered and evaluated by the trial court. Case law reveals that whereas the judicial scrutiny and recount report is not binding on the trial court, it must be considered, evaluated, and weighted with all other evidence. The trial court cannot ignore, overlook, and fail to refer to the report. The court must analyze the report and either adopt its findings or discount the registrar's finding. In the instant appeal, a question that arises is whether the trial court ignored or failed to consider the Deputy Registrar's scrutiny and recount reports, and thereby arrived at a wrong conclusion based on the evidence on record. Did the trial court consider and evaluate the Deputy Registrar's report? At paragraph 160 of the judgment, the trial court held that irregularities and/or discrepancies established by the petitioners was corroborated by the report of the Deputy Registrar dated 21st of November 2017 on the access orders made by this court on 7th and 15th November 2017. Our plain reading of paragraph 160 of the trial court's judgment shows that the court did not consider and evaluate the Deputy Registrar's scrutiny and recount report. It is manifest that the trial court neither considered nor evaluated this report. The court never adopted or discounted the contents of the report. It is the failure by the trial court to mention, to refer to, consider, or adopt, or discount or evaluate the registrar's scrutiny and recount reports a fundamental error of law. At this stage, we must take a clear distinction between the Deputy Registrar's report dated 21st November and the scrutiny and recount report dated 24th of January 2018. As regards the report dated 21st November 2017, the trial court found that the petitioner's evidence was corroborated by the Deputy Registrar's report dated 21st November 2017. We shall revert to consider if this holding is supported by the evidence on record. We note that the Supreme Court in the Nicholas Kitoara Police Salat case affirmed that the determination of sufficiency of evidence is a task reserved to the discretion of the election court. In our view, evaluation of contents of a document can be either verbose or succinct. It may be a rehashing and reproduction of excerpts of the content or a synopsis of content. It is all a question of style. In the instant case, the trial court neither mentioned nor alluded to the existence of the DR scrutiny and recount report dated 24 January 2018. Emerging jurisprudence shows that a judicial scrutiny and recount report must be considered, evaluated, and weighted with all other evidence on record. Guided by the emerging jurisprudence, we find that the trial court erred in law in failing to mention, considered, and evaluated the DR scrutiny and recount report dated 24th of January 2018. As regards the Deputy Registrar's report of 21st November 2017, we find that the trial judge, brief as he was, did not ignore the report. He considered it, evaluated it against the entire evidence on record, and arrived at a determination that the report was corroborative evidence. We shall determine if this holding is supported by the evidence on record. Accordingly, we find the contestation by the appellant that the trial court erred in ignoring and not considering the DR scrutiny and recount report has merit. The burden of proof and the question of burden of proof and whether the trial court erred in his finding on failure by the appellant, the first and second respondents to call witnesses. The appellants contend in rounds 16, 17, 18, 19, 21, and 22 of the Memorandum of Appeal that the trial court erred in holding that the presiding officers who conducted elections on behalf of IEBC must have been called to testify in relation to the disputed polling station. The first and second respondents in their cross appeal also contend that the trial court erred in drawing an adverse inference that they did not call presiding officers and the IEBC polling station agents to testify. The appellants contend that the DR's scrutiny and recount report of 24 January and 21st November showed that the results by IEBC were authentic and there was no interference with the ballot boxes and the contents thereof. That even if there are any irregularities as to the signing of any statutory form, the scrutiny and recount report cures and obliterates such irregularities as the will of the voters is determined through scrutiny and recount of ballots. It was submitted that the trial judge erred in law in holding that the presiding officers ought to have called to rebut the evidence of the third and fourth respondents. That the judge erred in holding that the appellants should have called as witnesses their agents at the disputed polling station. That in so doing, the trial court erred and shifted the burden of proof to IEBC and the appellants. This court is alive to the fact that there is no legal requirement in law on the number of witnesses to prove or disprove a fact. Section 143 of the Evidence Act, we state what Section 143 of the Evidence Act provides. When a person fails to call a relevant witness to prove or disapprove a fact in issue, a trial court may draw an adverse inference from the failure to call such a witness. This court in Mohammed Abdi Mahmoud versus Hamid Abdullahi Mohammed, in affirming the trial court decision drawing an adverse inference for failing to testify and shifting of evidential burden of proof, expressed itself as follows, and I quote, "The cavalier attitude evinced by the appellant in the face of serious questions about his eligibility to vie for the seat of governor was compounded and rendered tragic by his choice to stay away from the proceedings and therefore not only failed to present his side of the story, but also keep himself from being cross-examined on his replying affidavit, thereby robbing it of any probative value. The learned judge in his analysis of the evidence and the appellant's failure to present himself in court expressed himself as follows. I've taken note of the fact that although the first respondent had the opportunity to either deny or challenge all these facts, he did not do so in his replying affidavit. He also failed to appear in court and shed light on this issue. The petitioner's evidence therefore remained uncontroverted. The petitioners have therefore succeeded in shifting the evidentiary burden of proof to the first respondent." End of quote. In the instant case, did the trial court err in drawing an adverse inference against the appellants and the first and second respondents for failing to call their agents and presiding officers respectively? Did the burden of proof shift? The provision of Section 143 of the Evidence Act is useful but must be read together with other relevant provisions of the Evidence Act. Section 108 of the Evidence Act states as follows. The burden of proof in a suit or procedure lies on that person who would fail if no evidence at all were given on either side. While Section 109 of the Evidence Act states that the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. An adverse inference ordinarily should not be drawn simply because a respondent has chosen not to call any or some of the witnesses. The legal burden of proof always remains with the petitioner, and a court should be careful not to draw an adverse inference when a respondent who has no legal burden to prove any fact fails to call a witness or witnesses. In the instant case, the critical issue is whether from the evidence tendered before the trial court, the evidentiary burden had shifted to the first and second respondents to warrant that they disprove the facts prima facie established by the third and fourth respondents in the petition before the trial court. In the petition, the third and fourth respondents named the following presiding officers as having colluded with the appellants and the first and second respondents. The presiding officers named included Patrick Onyango Were, Jacob Nyakinda, Kennedy Ogae, Crispin Homa, and Enoch Owenga, all in Karachuonyo constituency. In Kabondo Kasipul constituency, the presiding officers named were Tobias Ondiege Oduro and Hastings Ocheng Jared. Humphrey Odhiambo and Dave Okoth were named in Rangwe constituency, while Okoth, Paul Oulo Onyone, Sheila Okoth, and Samuel Ouma Okoth were named in Thiwa constituency. It was contended by the third and fourth respondents that all these presiding officials were involved in electoral fraud, malpractices, and electoral offences in their respective polling stations and ought to have been called by the first respondent to testify. The question whether the trial court erred in holding that the presiding officers who conducted the elections on behalf of IEBC should have been called to testify depends on whether the third and fourth respondents had laid prima facie evidence that required IEBC to explain. If prima facie evidence was laid, then the evidential burden of proof shifted to IEBC. On our part, having examined the record, we are satisfied that the evidential burden of proof had shifted to IEBC for the following reasons. First, the trial court established as a fact at paragraph 180 of its judgment that the documents put in evidence by the third and fourth respondents originated from IEBC. Second, the trial court established as a fact at paragraph 178 that there were some irregularities in the documents tendered in evidence by IEBC. Third, the trial court noted at paragraph 176 of the judgment that there was prima facie evidence that the results declared at the polling station were different from those declared at the constituency tallying centers and at the county tallying center. Fourth, there is prima facie evidence on record that some statutory declaration forms were not signed by presiding officers and that some forms did not have stamps. Based on the findings of fact as established by the trial court, whereas we find that the trial court did not err in holding that the evidential burden of proof had shifted to IEBC, we find that the court erred in drawing an adverse inference that failure to call agents and presiding officers is fatal. At a prima facie level, some evidence had been laid before the trial court that required explanation or clarification by IEBC. It is not the law that such explanation or clarification can and must only be given by agents or presiding officers. Other cogent, convincing, and corroborative evidence to explain or clarify any irregularity can be laid by the IEBC. We remind ourselves and restate that IEBC as a respondent in election petition has no legal burden to prove that an election was conducted substantially in compliance with constitutional principles and election laws. However, just as any respondent, if a prima facie case has been laid against the IEBC, the evidential burden shifts and failure to discharge this burden may convert the prima facie evidence into evidence proving the disputed fact. We find that the trial courts erred in holding that the presiding officers who conducted elections on behalf of IEBC must have been called to testify on results in disputed polling station. There is no legal obligation on the part of the respondent to call any witness to testify. In this context, we affirm the dictum in John Munuve Mati versus Returning Officer Mwingi North Constituency and IEBC, where it was held that it does not invariably follow that failure by a respondent to call a witness means that the petition must be allowed. Is the judgment by the trial court inconsistent in light of Articles 81 and 86 of the Constitution, as read with Section 83 of the Elections Act? The appellants, through learned counsel, Dr. Otiende Amolo, submitted that the judgment of the trial court was inconsistent and should be set aside. It was submitted at paragraphs 83, 97, 98, and 99. It was submitted that at paragraphs 83, 97, 98, and 99 of the judgment, the trial court gave a clean bill of health to the gubernatorial elections. That surprisingly, at paragraphs 179, 184, and 189, the trial court makes an about turn and finds that the conduct of elections was not free and fair. Based on these observations, the appellants urge us to find that the trial court erred in nullifying the elections, as these conclusions are contradictory and are not based on the evidence on record. In making the contested remarks which we have reproduced in this judgment, the trial judge was considering the second issue for determination as identified by the court. In our view, in considering the second issue, the trial court was faced with qualitative and quantitative aspects of the conduct of the elections. The qualitative and quantitative aspects of the electoral process have four distinct stages, which we have stated herein. In any election petition alleging or founded on qualitative or quantitative violations of Articles 81 and 86 of the Constitution, for the petition to succeed, a petitioner must demonstrate that in any of the four qualitative or quantitative stages, there was substantial or material non-compliance with the constitutional and electoral laws governing the elections.
Na mtazamaji, basi hicho ni kikao cha kutoa hukumu kuhusu rufaa iliyowasilishwa na gavana wa kaunti ya Homa Bay Bwana Cyprian Awiti kupinga uamuzi wa mahakama kuu kufutilia mbali ushindi wake. Alikuwa mbunge wa Kasipul Oyugi Magwanga alikuwa amewasilisha kesi ya kupinga uchaguzi wa Magwanga katika mahakama wa Cyprian Awiti katika mahakama kuu na kushinda. Magwanga alimalizia wa pili katika uchaguzi mkuu wa mwaka 2017 uliopita, lakini jaji wa mahakama kuu Joseph Karanja alisema tume ya uchaguzi IEBC ilishindwa kuandaa uchaguzi ulio huru na haki, na hivyo kufutilia mbali ushindi wa Cyprian Awiti, na ndipo basi bwana Cyprian Awiti akaweza kuwasilisha hii rufaa mahakamani. Mtazamaji, hebu tuzidi kumsikiza jaji.
It is in this context that the court expressed itself as follows, and I quote, "It is clear that the impugned gubernatorial election was largely conducted in a manner which was proper, peaceful, and free from violence, intimidation, and any other breaches of the law." End of quote. In further support of his finding that the polling, balloting, and voting process did not violate any constitutional principle, the trial court stated that it was evidently clear that up to and during the voting, the process was conducted reasonably well and in accordance with the law. After finding that the conduct of the election on the polling, balloting, or voting day was free and fair, the trial court embarked on determining whether the post-poll process of collating, tallying, transposition, signing of the statutory forms, and final declaration of results was free and fair. In our considered view, the submission by the appellants that the judgment of the trial court is inconsistent has no merit. The judgment by the trial court is not inconsistent. The appellant's contestation does not take into account that there are four distinct stages in determining the qualitative aspects of the conduct of election. In his judgment, the trial court properly considered the qualitative aspects of the conduct of election to determine if the post-balloting process of collation, tallying, transposition, and declaration of results substantially complied with Articles 81 and 86 of the Constitution. It is in this context that we adopt the Supreme Court dictum in Raila Amolo Odinga and another. As to whether the trial court erred in relying on documents tendered by the third and fourth respondent as true results and ignored documents tendered by the first and second respondents, this is what we have to say. The appellants contend that the trial court erred in relying on those documents tendered by the third and fourth respondent as true results for the gubernatorial elections and ignored documents that are statutory forms containing the official results declared by IEBC. What are the documents tendered in evidence by the parties? The documents are forms 37As that are filed at the polling station, filled at the polling station. The third and fourth respondent tendered in evidence original carbon copies of Form 37As, which they claim were given to their agents at the polling station by the IEBC officials. On the other hand, the first and second respondents produced scrutiny and recount Form 37A, which they assert were the original Form 37As retained by the presiding officer at each polling station. There were 1,062 polling stations in the gubernatorial elections. This means that there were 1,062 Form 37As. The issue in contention in this appeal is that there is allegation that some of the contents and entries in Form 37As tendered in evidence by the third and fourth respondents are different from the content and entries in Form 37As tendered in evidence by the first and second respondents. It is also alleged that there are alteration in figures without countersigning and that some of the forms are not signed by the presiding officers. In order to resolve this dispute, the trial court orders scrutiny and recount. On our part, we have agonized if we have jurisdiction to disturb and interfere with the findings of fact and credibility of witnesses as determined by the trial court in relation to Form 37As. In principle, this court cannot interfere with findings on credibility of witnesses. However, we can interfere with findings of fact made by the trial court if any of the following conditions are fulfilled. 1. If the conclusions arrived at by the trial court is based on no evidence, or 2. If conclusions arrived at by the trial court is not supported by established facts or evidence on record, or 3. If the conclusions are so perverse or so illegal that no reasonable tribunal would arrive at the same. In this context, we remind ourselves of the dicta from the Supreme Court in the case of Gatirao Peter Munya, which enjoins this court to show deference to the trial court on the findings of fact and credibility of witnesses. The contestation on the source, content, authenticity, and probative value of Form 37As tendered in evidence by the third and fourth respondents vis-a-vis Form 37As tendered in evidence by the first and second appellants lead us to appraise the law on documentary evidence on authenticity and proof of documents. Documentary evidence and proof of the authenticity of Forms 37As tendered in evidence by the third and fourth respondents. The appellants and the first and second respondent contend that Form 37As tendered in evidence by the third and fourth respondents are hearsay documents, that they are forgeries and the trial court erred in fact and in law in relying on forged documents. Conversely, the third and fourth respondents contend that Form 37As they tendered in evidence are not hearsay documents because they are true carbon originals given to their agents at the polling station by the presiding officers of IEBC. Section 64, 65, and 67 of the Evidence Act are relevant to this contestation. Contents of documents may be proved by either primary or secondary evidence. Primary evidence means the document is self-produced for inspection by the court. Where a document is executed in several parts, each part is a primary evidence of the document. Where a document is executed in counterpart, each counterpart being executed by one or some of the parties only, each counterpart is primary evidence as against the parties executing it. Where a number of documents are all made by one uniform process, and as in the case of printing, lithography, or photography. Each is primary evidence of the contents of the rest, but where they are all copies of a common original, they are not primary documents. The trial court at page 180 of its judgment made a finding of fact on the source and authenticity of the documents tendered in evidence by the third and fourth respondents. It was held that these documents originated from the first and second respondents. Critical to the issue of source and authenticity of the third and fourth respondents' documents, the first and second respondents in their written submissions state that all forms annexed in volume 4 of the third and fourth respondents originated from the polling stations and have all the requisite features. That the said forms were later altered by the third and fourth respondents. This submission by the first and second respondent confirms the trial court's finding that the third and fourth respondents' documents are authentic and came from the legal source, namely they came from IEBC. Accordingly, we find that the trial court did not err in finding that the documents tendered in evidence by the third and fourth respondents were authentic and came from IEBC. In our analysis of the record, having found that the documents put in evidence by the third and fourth respondents were authentic, we note that pursuant to section 64 and 65(1) of the Evidence Act, the original statutory forms ought to have been produced in court by IEBC to establish the contents of the statutory forms used to declare results and to ascertain the accuracy and verifiability of the results at each polling station. We note that Senior Counsel Tom Ogenda for the appellant submitted that the documents tendered in evidence by the third and fourth respondents were hearsay documents. The trial court noted this submission at paragraph 67 of its judgment, where the judge stated that the third and fourth respondents contend that the petitioners relied on hearsay evidence from their so-called undocumented chief agent and have not shown any proof of their documented agents who allegedly collected the Form 37As from the polling station. The trial court further noted the contention by the appellants and the first and second respondents that the Form 37As put in evidence by the third and fourth respondents were forgeries. At paragraph 68 of the judgment, the trial court observes that, I quote, "It is contended that the origin and authenticity of the purported Form 37As as provided by the third and fourth respondents are suspect," end of quote. On a comparative basis, it has been recognized that duplicate or originals have the same evidentiary status as an original. The duplicate in legal conception is an original instrument repeated. This is illustrated in cases where a carbon impression is simultaneously produced by the same stroke that creates an original. On our part, we disagree with the contention that the documents tendered in evidence by the third and fourth respondents were hearsay. First, there is nothing on record to show that the appellant objected to admissibility of these documents. Second, the first and second appellants have, through their submissions in this appeal, confirmed that the documents originated from them. Third, the first and second appellants have accepted in this appeal that the documents originated from them. The issue of the authenticity of the documents is closed. Fourth, under section 65, subsection 2 and 3 of the Evidence Act, the documents tendered in evidence by the third and fourth respondent were executed in several parts or in counterpart, and they prima facie qualified to be primary documents. Now, the preliminary objection on Rules 8, Sub-Rule 4B and 12(1)B of the Elections, Parliamentary and County Election Petition Rules 2017. In ground 28 of the Memorandum of Appeal, the appellants contend that the trial court erred in law by ignoring the preliminary objection raised to dismiss the petition for failure to comply with the mandatory requirements of Rule 8, Sub-Rule 4B and 12, Sub-Rule 1B of the Election, Parliamentary and County Election Petitions Rule. These grounds
Basi mtazamaji, hayo ndiyo matukio katika mahakama ya Kisumu, ambapo ni kesi kuhusiana na eneo hili ama basi kaunti ya Homa Bay, mtazamaji, ambapo ni uamuzi wa rufaa yake gavana Cyprian Awiti dhidi ya Oyugi Magwanga ambaye aliwasilisha kesi mahakamani na akaweza kushinda. Kisha baada hapo basi ndipo Cyprian Awiti aliamua kuweza kuwasilisha ile rufaa mahakamani, na inasomwa siku ya leo, ambapo bwana Cyprian Awiti atakuwa anajua hatima yake, iwapo basi atazidi kukalia kile kiti cha ugavana ama hali itakuwaje, iwapo basi